Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. One of our subscribers, Donna, has asked if we could do a video on why big companies always incorporate in Delaware. I thought it was a good question, and the answer relates, at least in large part, to a legal principle called the business judgment rule. The business judgment rule is a legal principle that governs the decisions made by directors and officers of a corporation. It essentially provides protection to these individuals from personal liability for their decisions if they act in good faith, with the care that an ordinarily prudent person in a similar position would exercise, and in the best interests of the corporation. Here is what the state's corporation website says about the business judgment rule. Business judgment rules. Although some major transactions require the consent of stockholders as well as the approval of the board generally has the power and duty to make the business decisions for the corporation. These decisions include establishing and overseeing the corporation's long-term business plans and strategies and the hiring and firing of executive officers. Delaware law affords directors making such decisions a set of presumptions known as the business judgment rule that so long as a majority of the directors have no conflicting interest, and that deals with duty of loyalty, in the decision, their decision will not later be second-guessed by a court if it is undertaken with due care and in good faith. The business judgment rule, which applies even if the business decision later turns out to have been unwise, is the centerpiece of Delaware corporation law. Now, Delaware has a rich body of law that interprets and applies the business judgment rule. While there are numerous cases that have contributed to the development of the corporate law in Delaware, several stand out as particularly significant in shaping the application of the business judgment rule. Here are a few notable ones. Smith versus Van Gorkum, which is a 1985 case. This case is often cited as the most important in Delaware corporate law history. In Smith, the Delaware Supreme Court held that directors could be held personally liable for a breach of their fiduciary duties of care if they approve a merger without adequately informing themselves of all material information reasonably available to them. This case emphasized the importance of directors' duty of care and their obligation to be adequately informed when making business decisions. Revlon versus McAndrews and Forbes Holdings. In Revlon, the Delaware Supreme Court established the principle that when a corporation is in the process of being sold, the director's duty shifts from the traditional business judgment rule to maximizing shareholder value. The case clarified that directors must take reasonable measures to obtain the highest value reasonably available to shareholders in a sale transaction, even if it means sacrificing other corporate objectives. And in that situation, Revlon was sort of already on the brink of disaster, and so it had to be sold and it had to be liquidated. And as a result, instead of getting a poison pill or other things that would reduce the attractiveness of the corporate purchase, the directors had a duty to maximize the value, which is why they were held liable. In Unical, the Delaware Supreme Court addressed the issue of defensive tactics used by target corporations to fend off hostile takeovers. The court held that defensive measures taken by directors to thwart a takeover bid must be proportionate and reasonable in relation to the threat posed. The case established the enhanced scrutiny standard for reviewing defensive measures, which requires directors to show that their actions were reasonable in response to a perceived threat to the corporation. And then in re Walt Disney Company derivative litigation. In this case, the Delaware Court of Chancery addressed the duty of loyalty and potential conflicts of interest among directors. The court held that when directors face a conflict of interest, they must demonstrate that their actions were entirely fair to the corporation and its shareholders. This case reaffirmed the stringent standards applicable to director conduct in situations involving potential conflicts of interest. In that case, one of the issues was the firing of a chief executive, a guy by the name of Orvitz, and the payment of $130 million in severance to him based on his contract. The important part of that is that the business judgment of the corporate directors was upheld because if they could have found any way to avoid paying it because they just really didn't like the guy, they would certainly have done it. And that was pretty much what the trial court actually concluded in that case. And then we have air gas products versus air products and chemicals. The case dealt with the issue of shareholder rights plans, commonly known as poison pills, which are designed to deter hostile takeovers. The court held that in certain circumstances, directors may use poison pills to protect shareholders from coercive or unfair takeover attempts. However, the court also emphasized that directors must act in good faith and in the best interests of the corporation when implementing such defensive measures. These cases represent significant milestones in Delaware corporate law and have shaped the application of the business judgment rule, providing guidance on directors' duties, defensive measures, conflicts of interest, and shareholder rights. When it comes to the decision of where to incorporate, particularly in the United States, the business judgment rule can have a significant impact on a corporation's choice of Delaware as its state of incorporation. Here's how. First of all, legal precedent. Delaware, as I just went through, has a long history of corporate law and well-developed body of case law that interprets and applies the business judgment rule. Courts in Delaware typically defer to the decision of directors and officers as long as they fulfill their fiduciary duties. This predictively and consistently in legal outcomes provides a level of comfort to corporations and their leadership. Flexibility and protection. Delaware's corporate laws are considered to be business-friendly and provide a high degree of flexibility in structuring corporate governance. The statutes offer various legal mechanisms that allow corporations to protect directors and officers from personal liability, such as indemnification and exculpation clauses in corporate bylaws or charters. This, combined with the business judgment rule, offers strong legal protection to corporate decision makers. And then, specialized courts. Delaware has a separate court system, the Delaware Court of Chancery, which specializes in corporate law matters. You may have recently seen where that very court decided that Elon Musk couldn't take a $40 million salary. The judges in this court are highly experienced in handling corporate disputes, and their decisions are often set precedents followed by courts in other jurisdictions. This specialized court system contributes to the efficiency and expertise in resolving corporate disputes, further enhancing Delaware's appeal to corporations. Shareholder-friendly laws. Despite being favorable to management, Delaware's corporate laws also provide certain protections and rights to shareholders. For example, Delaware law allows shareholders to bring derivative lawsuits on behalf of the corporation for breaches of fiduciary duty, thus providing a mechanism for shareholder oversight. So when a corporate director puts his best interests ahead of the corporation's best interests, that's a breach of his fiduciary duty to the corporation, and the corporation can be held liable, or the director can be held liable in that situation. And then market perception. There is a prevalence among large corporations that Delaware incorporation is essentially a gold standard for corporate law. This perception can be advantageous for a corporation's reputation as it signals to investors and business partners that the company is governed by well-established legal principles and standards. Among the people who are in the CEOs and in the C-suite, I guess, of large corporations, Fortune 500 corporations, if they see that a company is incorporated in Delaware, there is a presumption that attaches that says basically, okay, these people know what they're doing. But if somebody is incorporated in another state, Iowa, Kansas, someplace like that, that presumption may not apply. So that can be another good reason to incorporate in Delaware. In summary, the business judgment rule significantly influences a corporation's decision to incorporate in Delaware by offering legal protection and predictability to directors and officers, along with a favorable legal environment conducive to corporate governance. Now, while it is a popular choice for incorporation due to its business-friendly and legal environment and well-established corporate laws, there are also some potential disadvantages to incorporating in Delaware. First of all, there are franchise taxes and fees. Delaware charges annual franchise taxes and various fees for maintaining a corporation in the state. While these fees are often considered reasonable compared to the benefits of incorporating in Delaware, they can still represent an ongoing cost for businesses, particularly smaller companies or startups with limited resources. There is a registered agent requirement. Delaware requires corporations to have a registered agent with a physical address in the state. This can be an added administrative burden and expense, especially for businesses that don't operate primarily in Delaware. For example, if the corporate headquarters is in Ohio, they have to employ somebody in the state of Delaware to accept service of process, which is what a registered agent does. Jurisdictional requirements. While Delaware's corporate laws are well established and respected, operating a business in multiple states may require compliance with the laws and regulations of each state where the business conducts activities. For example, if you have a corporate entity who is registered as a Delaware corporation and you want to do business in Missouri, you have to register that corporation with the Secretary of State as a foreign corporation, and you have to have a registered agent for service of process in the state in order to accept it if you do get sued. Now, that can result in added complexity and administrative burdens, especially if a business must qualify to do business as the foreign corporation. One of the problems that sometimes happens is if you have a corporation that is headquartered in one state, like Missouri, but is a Delaware corporation, and they get sued, and the process is served in Delaware, and the registered agent doesn't get it back in time to the people in Missouri to deal with, well, then you've got a problem with maybe hitting a default judgment or having a default judgment entered against you. There are some little wrinkles in the system in terms of how you are incorporated and where you're incorporated. Usually that doesn't happen, but every year it seems there are at least 2 or 3 cases where somebody who is incorporated in a different location misses the deadline to respond to a lawsuit and has to ask for forgiveness from the courts in that situation. Finally, another issue is increased scrutiny. Because Delaware is a popular choice for incorporation, courts and regulators may scrutinize Delaware corporations more closely, particularly in high-profile cases or situations involving shareholder disputes. This heightened scrutiny can lead to more extensive legal proceedings and potentially increased legal costs. And there's less flexibility for small businesses. While Delaware's corporate laws offer flexibility for larger corporations, they're not as advantageous for small businesses or startups with simple organizational structures and fewer shareholders. In some cases, the additional requirements and formalities associated with Delaware incorporation may outweigh the benefits for a smaller corporation. Potential for shareholder litigation. Delaware courts are known for their expertise in handling corporate disputes, but that also means that shareholders may be more inclined to file lawsuits in Delaware, particularly in cases involving allegations of a breach of fiduciary duty or other corporate governance issues. While the business judgment rule provides directors and officers with some protection, shareholder litigation can be costly and time-consuming for corporations. Overall, Delaware incorporation offers many benefits. It's essential for businesses to carefully weigh those advantages against the disadvantages. One thing that I haven't mentioned so far is the fact that if you're a Delaware corporation and you seek bankruptcy protection, you go into the Delaware courts in bankruptcy. Those bankruptcy courts in Delaware are very favorable to the corporation. Pretty much anything the corporation wants in bankruptcy that is legally allowed is most likely to be granted by the courts there. They tend to be just exceptionally deferential to the corporate interests. That's sort of the reason why people incorporate in Delaware. It offers a number of significant advantages if you are a big corporation or if you ever intend to be a big corporation, in that it protects the officers and directors from what they would call frivolous lawsuits and what many of us in the legal business would call actual lawsuits, because they try to hold corporate directors and officers responsible for bad decisions that are made without good information and in breach of their duties to protect the corporation and put the corporation above their own personal interests. I think it's worth noting that many of those corporations that fall into that category, in other words, people who make bad decisions and ultimately wind up causing the corporation harm, wind up in bankruptcy court in Delaware, where the bankruptcy judges tend to essentially pamper them. Now, I'm not saying the judges are doing anything unethical or wrong. I'm just saying that's my perception, that judges there tend to treat them with kid gloves. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff you can do. You can email me at the address above, as the person did who asked for this video. So again, thank you for watching. If you have the opportunity today, do something nice for someone, and then come back here tomorrow and catch me at the beach. Thanks, and have a great day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.